This is Barry Zelma speaking for Zelma on Insurance, the blog. Today we're going to speak about the fact that Greg Lindberg gets a new trial from the Fourth Circuit Court of Appeal on the basis that the Fourth Circuit concluded that a jury instruction misled the jury by stating that an official act existed as a matter of law, rather than as a piece of evidence that must be decided by the jury. Greg E. Lindberg and John D. Gray were convicted of honest services fraud and federal funds bribery in connection with a series of payments and offers of payment in the form of campaign contributions made to Mike Causey, the elected insurance commissioner for North Carolina. The jury found that these payments were made in exchange for Causey assigning a different deputy commissioner to oversee the affairs of Lindberg's insurance companies. In United States of America v. Greg Lindberg, a decision of the Fourth Circuit Court of Appeal dated June 29, 2022, the Fourth Circuit reversed the verdict and granted Lindberg and Gray a new trial. Greg E. Lindberg had served as chairman of Eli Global LLC, an investment company, and as owner of Global Bankers Insurance Group, an insurance management company, during the relevant period from April 2017 to August 2018. Lindberg owns several insurance businesses subject to regulation in North Carolina. John D. Gray worked as a consultant for Lindberg during the relevant period. Lindberg and Gray, the defendants, were convicted of conspiring to commit honest services wire fraud and federal funds bribery for offering millions of dollars in campaign contributions to Mike Causey, the commissioner of the North Carolina Department of Insurance, in exchange for reassignment of a senior deputy commissioner assigned to review Lindberg's insurance companies. In November of 2016, Mike Causey was elected as North Carolina's Commissioner of Insurance, although Lindberg wanted a different person and funded the campaign of a different person. Several weeks after he was elected, Causey was scheduled to meet with Lindberg and other members of Eli Global's leadership. Prior to the meeting, he received a phone call from his campaign treasurer notifying him that he had received a $10,000 donation from Lindberg. Causey testified he thought the contribution was unusual, both because of the size and the timing, and he decided to return the donation. At the meeting, Gray explained that Eli Global was in the process of purchasing another insurance company based in Michigan and asked Causey to call his counterpart in Michigan to put in a positive word. Causey agreed and made the phone call. Causey testified at trial that Gray then called him to state that Lindberg had donated $500,000 to the North Carolina Republican Party, with $110,000 to be sent to Causey's campaign, and that Gray and Lindberg wanted to host a fundraiser for Causey in December. Causey later reached out to the Federal Bureau of Investigation to express his concerns about these offers of donations, and agreed to cooperate with an FBI investigation into Lindberg and his associates. Over the course of several meetings, they discussed Lindberg creating an independent expenditure committee and donating substantial amounts, between $500,000 and $2 million, to Causey's re-election campaign. The day after the meeting, Causey's campaign received $230,000 from the North Carolina GOP. In total, Causey received $250,000 in donations funneled through the party. Following the conclusion of the investigation, the defendants were each charged in March of 2019 with one count of conspiracy to commit honest services fraud and one count of federal funds bribery and aiding and abetting the same. Defendants pleaded not guilty, and a jury trial was held from February 18 to March 5, 2020. At trial, defendants in the United States both objected to the district court's proposed jury instruction defining an official act. Both parties agreed that the issue of what qualifies as an official act should be left for the jury. The district court denied both objections. Further, the district court prevented the defendants from arguing or putting on evidence to show that the reassignment was not an official act. After 3 days of deliberation, Gray and Lindberg were convicted on both counts. Defendant Gray was sentenced to a term of imprisonment of 30 months, and Lindberg was sentenced to a term of imprisonment of 87 months. The trial court stated, in no uncertain terms, that the removal or replacement of a senior deputy commissioner by the commissioner would constitute an official act. In McConnell v. United States, the Supreme Court defined honest services fraud with reference to Section 201 of the federal bribery statute. In particular, the court imported the official act requirement and found that the government was required to show that Governor McDonnell committed or agreed to commit an official act in exchange for the loans and gifts. Section 201A3 defines the term official act, and the Supreme Court narrowed the definition of the term. Quote, in sum, an official act is a decision or action on a question, matter, cause, suit, proceeding, or controversy. The question, matter, cause, suit, proceeding, or controversy must involve a formal exercise of governmental power that is similar in nature to a lawsuit before a court, a determination before an agency, or hearing before a committee. It must also be something specific and focused that is pending or may by law be brought before the public official. To qualify as an official act, the public official must make a decision or take an action on that question, matter, cause, suit, proceeding, or controversy, or agree to do so. Close quote. Although the district court properly defined the term official act according to the directive of McDonnell, it then instructed the jury that the removal or replacement of a senior deputy commissioner by the commissioner constitute an official act as a matter of law. The Fourth Circuit found that in doing so, the district court impermissibly took an element of the crime out of the hands of the jury and violated the defendant's Fifth and Sixth Amendment rights. The district court erred, however, in interpreting official act inquiry to be a pure question of law, but was rather a question of fact for the jury to conclude. The Supreme Court was clear in McDonnell that it is up to the jury under the facts of the case to determine whether the public official agreed to perform an official act at the time of the alleged quid pro quo. And the McDonnell court clearly considered it the province of the jury to determine what constitutes an official act. Having determined that the district court improperly instructed the jury on the official act element, the Fourth Circuit was then required to determine whether the error requires vacating the convictions. A constitutional error, for example, is harmless when it appears beyond a reasonable doubt that the error did not contribute to the verdict obtained. However, the Fourth Circuit decided that it could not conclude beyond a reasonable doubt that the jury verdict would have been the same absent the error. As a result, the Fourth Circuit concluded that the instructional error was not harmless as to count one, and therefore the defendant's verdict in count one must be and was vacated. Count two, the federal funds bribery charge, also required a finding of an official act. Congress expressed its clear intent to reach the conduct of state and local officials where such officials are agents of a covered entity that receives $10,000 or more annually in federal funds. Congress is within its prerogative to protect spending objects from the menace of local administrators on the take. In conclusion, the district court erred by instructing the jury that an official act, an element of the crime of honest services fraud, was present as a matter of law. Further, the error was not harmless, and therefore the Fourth Circuit vacated the defendant's convictions on both Count 1 and Count 2 because it found the verdicts were improperly infected by the instructional error on Count 1, and the case was remanded for a new trial. In my opinion, Lindberg and Gray's actions properly caused concern for the newly elected insurance commissioner, Mr. Causey, because of the large dollar amounts from two people who supported and contributed to his opponent. He, to protect himself, called in the FBI, who, working with him, gathered sufficient evidence to indict Lindberg and Gray, tried them to a jury, and convicted them. The Fourth Circuit reversed only because Lindberg and Gray, who are still serving in prison, and although they've moved the court to allow them to be released for the new trial, the court did not comment on their guilt, only that the trial court's error tainted the verdicts. They could still be tried again and convicted again as long as the trial court uses an appropriate instruction. Thank you for your attention.